what California calls an open carry law, has been exposed in federal court as little more than legal window dressing. What's up, everyone? This is Ted from Line 45, and today I'm breaking down the case that cracked California's gun law facade wide open and showed just how deep the state's carry rights deception really runs. Before I start, I would really appreciate it if you would push those buttons below, the subscribe button, the notification bell, all of them. This is not necessary, but those little clicks help a brother out. Plus, it pushes me to give you more valuable car-related content on your screen. Now, buckle up, and let's get back to the video. I've been around long enough to know when a law is written to fool the courts more than to serve the public. That's what caught my eye about California Penal Code Section 26150, subsection B, paragraph 2. On paper, it sounds like a fair deal. California allows open carry permits in counties with under 200,000 residents. But once you scratch beneath the surface, you find out it's just legal theater. Not a single permit has been issued under that clause. Not in 10 years. Not in a single one of those qualifying counties. That's not a coincidence. It's structure. The guy who finally said enough was Mark Baird, a California resident who tried to do it by the book. He wasn't trying to carry in Los Angeles or downtown San Francisco. He lived in Siskiyou County, population barely 45,000. By the state's own law, he should have had a pathway to open carry. But there was no application process, no procedure, no forms. Just a ghost law with no follow-through. So Baird sued the state. And when that case reached the Ninth Circuit, everything California had swept under the rug started coming out in daylight. This wasn't a matter of oversight. The law was written so that the right to carry would exist only in theory, which is just enough to dodge legal accountability. That's what made this case different. It wasn't about changing the law. It was about proving the law never really existed in the first place. The courts couldn't ignore that once it was in their face. I've sat through a lot of oral arguments over the years, but hearing Judge Lawrence Van Dyke go off during Baird versus Bonta felt different, like someone on the bench finally stopped pretending. The man didn't sugarcoat it. When he said applying for an open carry permit in San Francisco was like asking NASA for permission to ride a rocket ship, it wasn't sarcasm for show. It was a judicial slap to the face of California's legal charade. He understood exactly what was going on, and he said it out loud. What made Van Dyke's remarks hit harder was how specific and grounded they were. He wasn't just venting frustration. He pointed out the absurdity of a law that gives counties the discretion to issue permits, then offers no way to apply, no accountability if they don't, and no consequences for shutting the door entirely. He asked the kind of questions the state didn't want to answer, because there were no good answers. Why hasn't a single person in a qualifying county ever received a permit? Why is there no application process? How is this constitutional? The other judges didn't jump in to save the state either. In fact, the panel as a whole seemed uncomfortable with what was unfolding, not just because the law was broken, but because it was clearly designed to stay that way. Van Dyke saw the open carry statute for what it really was, a legal placeholder California could point to while never actually honoring it. And he was done playing along. Have you ever watched a courtroom exchange and felt the whole thing shift? Like the judges stopped nodding politely and started realizing they were being played? That's what happened when California's legal team tried to defend its so-called open carry law in front of the Ninth Circuit. The moment the panel dug in, the cracks weren't subtle anymore, they were gaping, and nobody on that bench missed it. I paid close attention to that hearing. The judges asked one question that echoed like a shot on steel. How many permits have actually been issued under this law? The state's attorney danced around it, citing vague discretion, public safety concerns, and local authority. But it didn't matter. Everyone in that room knew the answer. 0. Not one permit. Not ever. It wasn't just Van Dyke. Judge Bumate and others pushed on the same pressure points. They kept coming back to the fact that a law, by definition, has to be usable. Rights can't be offered in theory and denied in practice. But that's exactly what the state was defending, a theoretical right, wrapped in procedural fog, with no path forward. There was a moment when the state attorney tried to suggest that the option to ask a sheriff was enough to satisfy constitutional standards. That didn't fly. You could hear it in the judge's tone. They weren't buying it. The oral arguments exposed the whole framework, a right that exists just long enough to survive paper scrutiny, and not 1 second longer in the real world. Try asking for an open carry permit in a rural California county and see where that gets you. You won't find a form, an application, or even a policy manual. That's not a glitch. It's how the state built it. The law under California Penal Code Section 26150, subsection B, paragraph 2 technically allows open carry in counties with fewer than 200,000 people. But in court, it became obvious that the entire mechanism was gutted from the start. There's no real oversight. Sheriffs have total discretion, and the state doesn't require them to process or even respond to requests. No deadlines, no appeal structure, just a dead-end road with a sign that reads, "Right this way," and no pavement under your feet. And that's what the Ninth Circuit started picking apart, especially when asked whether anyone had ever received a permit through this process. The answer was as empty as the law itself. This wasn't the case of a few bad counties dragging their feet. It was a full blueprint for denial, dressed up in legalese. That's why this case hit harder than most gun rights challenges. It exposed how the state avoided an outright ban by drafting a law that doesn't function. From the bench, it was clear the judges recognized the difference between a hard-to-access right and a deliberately unreachable one. This wasn't just regulation. It was sabotage through silence. And in the post-Bruin world, the courts can no longer pretend that a non-functional right is still a real one. Carry laws aren't supposed to change just because you cross a county line. But in California, that's exactly how it works. The state carved out a provision that says open carry is allowed in counties with fewer than 200,000 people, then turned around and gave zero infrastructure for enforcing it. What that creates is a two-tiered system where your Second Amendment rights depend entirely on your zip code, and not even in a consistent way. Here's the twist. Even in counties that qualify, the sheriffs don't issue permits. They don't have to. The law gives them total discretion with no accountability, and the state never intended to intervene. So the so-called rural access was never real to begin with. Meanwhile, folks living in urban areas like Los Angeles or San Francisco never had a shot. There's no way to apply, no historical precedent that justifies the ban, and no equal application of the law. That disparity became the center of gravity during the Baird v. Bonta oral arguments. The judges weren't just annoyed, they were concerned. One of them even asked, point blank, whether the state could justify making a fundamental right hinge entirely on geography. And there was no credible answer. The courtroom exposed what the statute's quiet supporters never wanted to admit. California's open carry law wasn't about public safety or rural exceptions. It was about hiding behind boundaries and avoiding a real fight over rights. When a right is dependent on your address, it's not a right. It's a privilege granted by politics. After the Supreme Court's decision in New York State Rifle and Pistol Association versus Bruin, the rules of the game changed. States like California could no longer justify restrictive gun laws using vague public safety concerns or interest balancing. Instead, they had to meet a real standard, one grounded in the Constitution's text, history, and tradition. That meant any restriction on the right to bear arms had to have a clear historical analog rooted in the time of the founding. And that's where California's open carry framework fell apart. In Baird versus Bonta, the Ninth Circuit judges pressed California hard on this point. Where's the historical precedent for denying people the ability to carry openly in public, even in rural counties? The state didn't have one. All it could offer were modern justifications wrapped in bureaucratic language. But under Bruin, modern justifications don't cut it. This wasn't just a weak defense. It was an admission that the entire permit system failed the constitutional test. The court didn't need to stretch to see it. When a law allows a right on paper but ensures no one can ever exercise it in practice, there's no tradition behind that, just obstruction. Bruin was the warning shot. Baird confirmed that California ignored it. The state clung to discretion and process to dodge accountability. But Baird made it clear, if a law violates the Second Amendment under the new test, it doesn't survive. No more interest balancing. No more hiding behind hypotheticals. Watching the Baird hearing unfold felt less like a legal review and more like a slow unraveling of a state-level fraud. Not fraud in the criminal sense, but in the structural, systemic way California sold a right it never intended to deliver. The judges didn't need whistleblowers or leaked memos. The scheme was baked into the law itself. On the surface, the law suggests fairness and access. But under scrutiny, it collapsed into what it always was, a loophole in reverse. Counties weren't issuing permits because there was never a process. Sheriffs weren't processing applications because there were no standards. The state didn't enforce anything because that's exactly how the statute was meant to function, on autopilot, with a dead engine. It was just enough to avoid court challenges before Bruin, but Baird came at a time when the judiciary finally had the tools to cut through the facade. Van Dyke and the rest of the panel didn't just ask tough questions. They cornered the entire framework. And when the state failed to justify even the basic existence of the permit system, it wasn't just a policy failure. It was proof that California maintained a fiction in its penal code, while stripping everyday people of any real means to exercise a fundamental right. What the case exposed wasn't a broken law. It was a deliberate design, crafted to preserve appearances while killing access. And now that the courts have seen it for what it is, California may finally have to answer for it.